Hi, my name is Diana Chavez. Thank you for joining our webinar. SunRay secures $10 billion annually for GC subs and suppliers. We're a national construction document service. Today, we have a great New Jersey webinar on getting paid faster with liens, bonds, and contracts by the amazing construction attorney, Joshua Quinter. Without further ado, I would like to introduce Joshua Quinter.
Thanks, Diane. I'm going to talk about liens, bonds, and contracts this morning, but the key thing to remember with payment issues, which is really what we're talking about here, is how do we create leverage? The basic phenomenon with construction contracts and payment issues is the trade-off of work for payment, and neither side wants to be over leveraged. The owner or the GC or whatever the case may be typically wants to not get over leveraged by paying way more than the value of the work that's been installed, and the contractor never wants to deliver, or the sub, whatever the case may be, never wants to deliver extraordinary amounts of work before they've gotten paid, because at that point the two sides become business partners with one side over leveraged. So the key in a lot of this is know what your available remedies are, and don't sleep on them. Don't allow yourself to get into a position where you're over leveraged, because that's really kind of the name of the game. So these are sort of the subjects I'm going to cover this morning. We have liens, which are very valuable tools, and I don't want to give anybody the misperception that they're not valuable, but they're also, I would use the word limited. So you want to sort of be aware of that. They are exceptionally powerful tools when used properly. Bonds is another way to do it. It often creates what I label as third-party leverage. Of course, you should always know what's in your contract, and in most cases, in New Jersey is no different. You will have statutory remedies that can be available to you. So let's talk about each one of these one at a time in a little bit more detail. And the idea here is to just conceptually understand where these leverage points are and what the tools are to create that leverage, so that if you get into a situation, you know which one you need to be looking at, and preferably you're going to go talk to your attorney, kind of have an idea of what needs to be done already. With liens in New Jersey, this is not a dispositive list, but these are the three that I run into, most of the time in my day-to-day work. That I want to talk about this morning. The first one is what New Jersey statutes call a construction lien. That is just another label for what most states call a mechanic's lien. These liens usually have to be filed 90 days after the last date worked. If you're beyond 90 days, you're without a remedy at that point in terms of a lien. You typically do not have to give notice. There are some very unique rules if you're in the residential space, so be aware of that and make sure you know. But the value of a construction lien in terms of leverage is that it attaches to the real estate of the owner for the unpaid contract balance. So there's two things that typically cause anxiety for an owner. One is having their property leveraged, and one that causes even more anxiety is having their property leveraged when they already have it leveraged, meaning there's a mortgage or something else in front of you or in front of your lien. Because by way of example, a mortgage on a property will typically contain a provision which prohibits additional liens being placed on the property, and the bank is usually none too happy when a construction lien shows up. So that's one of the ways that you create leverage with a construction lien. And of course, if you got to see it all the way through, nothing will irritate them more than if you go all the way through the process and you put the property that they own up for sale to pay for it. The next one is a remedy that's somewhat unique to New Jersey. I won't tell you that it's the only state that has them, but it's one of the few. And it's a municipal mechanics lien claim that you can use in public jobs. Typically, in a public job, you can't file a lien. It's just not permissible. But New Jersey has created this unique remedy where you can file a municipal mechanics lien if you're a subcontractor. And what it does is, instead of attaching to the real estate, it attaches to the contract balance being held by the owner, and basically freezes it like you would freeze a bank account. And as you might imagine, if you're a subcontractor, nothing makes a contractor more unhappy than putting in an application for payment and finding out that the owner's not going to cut a check because there's a municipal mechanics lien in place. And the owner has no choice in the matter. It's not discretionary. I won't tell you it never happens and the owner pays anyway, but the law does not make it discretionary. If they get hit with a municipal mechanics lien, they are not permitted by law to make any further payment until that issue is resolved, hence your leverage. And then, of course, the last lien, and I put it in here largely because it's often overlooked, is just a simple judgment lien. If you go through, whether it's a default judgment the easy way or a lengthy case, a judgment lien is a lien that attaches to any property that's owned by the defendant. It could be personal property, it could be real estate, it could be other things, and there's a lot of ways to create leverage. Unfortunately, this one's a little different because it's not pre-judgment attachment. You have to actually go through the whole legal process to get it. Now, you have a lot more ability and maneuverability to go find things that this lien will attach to, unlike the first two. But the first two you can get out of the gate without really having to prove a whole lot in terms of what I guess we can loosely call due process. So that's kind of an overview of the lien. So bonds, these are the four most common bond types that you bump into in the construction space. As a general proposition, leverage is created using bonds or bond claims because of what you effectively do by bringing in a third party who gives the quote unquote non-paying party the hairy eyeball. So you have payment bonds, which is a third party surety agreeing to pay someone if the principal on the bond, and the most typical setup is, the contractor has a bond on which they're the principal and the subcontractor puts a payment bond claim in. But that's the way that one works. A performance bond, it kind of flows the other way. It's usually called by the owner because or the GC calling this on the sub's performance bond because they feel as though the project schedule or the work's not getting done and there's no hope of it getting done, and they call the bonding company in to get that work finished. And the reason why that's a leverage point on a payment claim is because if a performance bond gets claimed, typically payment stops. So it's kind of a leverage point the other way. And you want to be aware, about striking that balance. You obviously don't want to give any more work away than you have to if you're not getting paid. But if there's a performance bond available and somebody, decides they're going to pursue that, it can change the leverages a little bit. You have lien bonds, which are typically used to remove liens from a property. They only work when it's real estate, so it would only work on a construction lien, not a municipal mechanics lien or a judgment lien. But what you've got there is a surety agreeing to cover any loss if the lien is proved to be valid, and it removes the lien from the real estate. So sureties don't like to pay out. So they're not going to write a lien bond without either a giant premium if they know they're going to have to pay out, or if they're pretty sure they're not going to have to, and they tend to give the other side that they're who's asking for the bond to get rid of a lien, again, give them the hairy eyeball and make sure that they're applying the requisite amount of pressure to get that payment made. And then the last one is a maintenance bond. This is typically used on large projects where there's punch list work and there's other things to be done, and parties want to be released. So the maintenance bond is a way to ensure that if you make final payments, there's still something that requires the contractor, the subcontractor, whatever the case may be, to come back and finish up punch list or anything else that might work. So let me talk for another second or two about the payment bond, just to give you an example. With the payment bond, typically what you're going to run into is the payment bond claim goes in, you're going to get a feedback from the surety, and then the surety starts asking the contractor loads and loads of questions. What's going on? Why haven't these people been paid? Creating pressure. And then the key element is there's typically some sort of collateral held by the surety. It may be a personal guarantee. It may be a general indemnity agreement. And what you're doing is you're creating a scenario where that third party really pressures the non-paying party. And sometimes the non-paying party thinks they have a really good reason to not pay, and the surety may back them. But you're creating more leverage by having some third party get involved in pressuring the non-paying party. So that's bonds. Let's move on to contracts. So contracts at the outset, what I'll say is the key with utilizing contract clauses, or one of the big keys, I should say, to utilizing contract clauses is to think about them when you're entering the contract. A lot of times you don't have the remedies you could have in terms of your contract clauses once the dispute over payment arises, because you didn't spend any or didn't spend sufficient time negotiating your contract to get those leverage points in there. So the three most common that come up is a provision which allows you to stop work if you're not getting paid. Some contracts have it in there, some contracts don't. If you're in a situation where you think there's a distinct possibility that you might not get paid, it's a good provision to make sure it shows up in your contract, because if you have a provision in there that says that if I issue 2 invoices and I haven't been paid in a row and I haven't been paid, I can stop work without penalty. That's a pretty powerful tool to have in your contract. Another one that I've been told by a number of parties, or lawyers, I'm sorry, who represent owners in particular, and having represented some owners myself, I can tell you the owners tell me the same thing, is a clause that allows for the contractor or whomever it might be to ask for proof of your ability to pay. Now, there's usually a triggering event, so it might be something like a change order, or a change order of a certain magnitude, where a party can say, okay, well, I'm not executing the change order or doing any more work until you prove to me that you actually have the funding to pay for this. Nobody likes to have to disclose their finances, personal or professional, but it's a valuable tool. And the AIA contracts, for, I can't remember off the top of my head if they still have it in there, but for a long time I know they had a clause like that in there. And then the last one is, of course, the one that everybody tends to argue about, and it ends up getting in there usually in some form or another, is the ability to recover interest and attorney's fees, because it's a big opportunity to leverage if somebody knows, well, I might have to not only pay them what I owe them, but I may have to pay them if they're, I have to pay their lawyer and pay interest on it if they end up winning the case. So that can create leverage too. But the key takeaway for contract clauses is think about the remedies that you want to have available to you and write them into the contract, because unlike statutes and liens and bonds, which are all governed by the law, with contracts you can be as creative as you want. You can create scenarios where you have the ability to create remedies that you can utilize later, as long as everybody else is willing to agree to it. So that's contracts. And then the last one is statutory remedies. And these are typically dictated by the type of project. So if you're on a federal public project, it's what we call the Miller Act, what we lawyers call the Miller Act. I won't bore you with a long explanation as to why it's called the Miller Act, but the long and the short of it is that it creates a structure in which, if payment is not made, and the payment is not being made for a good faith reason, that you are allowed to recover interest, penalties, and your attorney's fees. And then in New Jersey, you have well, every state for that matter, you have the Little Miller Act, which is the state version of the same statute. Now, why do you have two? The Miller Act only applies to federal public works. So say you're working on a military installation for the federal government, or you're building a VA hospital or something like that. Those will typically be Miller Act applicable cases. The Little Miller Act is for state work. So if you're working for the state of New Jersey building a new courthouse or a new municipal building, the Little Miller Act will typically apply. Another big one, roads. If you're building roads, you know, one of those two acts may apply. You might, and actually they both might apply depending on how it plays out. So if it's a, for example, a I-95 in New Jersey with state and federal funding, you know, it both might arguably apply. And then the last one, the New Jersey Prompt Pay Act, that's my label because that's what we lawyers generally call the private state statutes, or the state statutes for private work is a better way to say it, in the different states in the United States. We just call them private prompt pay acts. New Jersey has one. I will tell you, as someone who practices in a multitude of different states, that New Jersey's is not that strong. It doesn't have a lot of teeth. You can put it in there and it can change the leverages a little bit, but my own personal experience has been that when you include it, it doesn't really change the leverage points that much in your claim setting. So it doesn't mean don't make it, just understand that it's not as good a leverage point as some of the other things that might be available to you. So in conclusion, you have all of these different leverage points, and the reality of the situation is that in many cases, you're going to have more than one of these remedies available to you. And the trick of the trade, if you will, and where attorneys in particular can really come in handy, is to kind of be able to, from experience, read the situation and know which ones are going to give you more leverage. And as a very simple, quick example, I may have a case where a construction lien creates leverage, but I also understand that it's not likely to change the dynamics as significantly as something else. And so what I might do is file a construction lien and let it sit on the property with what I presume will be no response from the other side, and look for other ways to press the issue, perhaps with a statutory remedy claim along with a breach of contract if I have the right clauses in the contract. So it's a matter of figuring out which buttons to push and which order to push those buttons in, so that you can change the leverages in a way that ensures that you're going to get paid. So I appreciate everybody taking the time to listen this morning, and thank you very much. Should you have any questions, feel free to reach out.
Yes, hi. Thank you so much, Joshua. We do not have questions at this time, but please feel free to take a moment to review the presentation on Google if you can, and feel free to reach out. Like Joshua said, thank you so much, Joshua, for your time, and thank you everyone else.
Thank you.